So the next area we are going to begin is contract of agency. Special contracts we completed. First one, indemnity guarantee. Bail and pledge I told you now. And the next one we are going to start with one very important area called as contract of agency. So with regard to the agency chapter, what are all the important areas, what we need to concentrate? Let us first try to understand the whole idea behind the concept of agency. See here. First I will roughly explain you what is the concept behind the contract of agency. See here. Whenever I say contract of agency, there will be two very important parties. Number one is a principal. Number two is a agent. Agent la again there are two types are there. Number one, sub agent. Number two, substituted agent. Number two, substituted agent. One is a sub agent, another one is a substituted agent. Next one is a general agent. Means an agent is divided into three actually. Okay. What are the three? Two we have written already. The third one is most important one. The third one is called as mercantile agent. Which agent? Mercantile agent. About this mercantile agent, we are going to discuss 99% of the chapter. Okay. For example, wherever in any subject, if not contract act, some other law you are reading, companies act you are reading at CA Inter, CA Final. You are reading direct taxes, CA Inter, CA Final. At the time also I will come. At that time also when I use the word agent, agent represents what? This agent, not sub-agent and substituted agent. So 99% of the cases, the word agent always refer to mercantile agent. Sub-agent and substituted agents will come only if the words sub-agent and substituted agent are clearly used in the sections. First of all, everyone understood the logic clearly, yeah? Everyone? So we are now going to start with the area called as contract of agency. In agency, there are two parties, as I already said. One is a principal, another one is a agent. Who is a principal? Who is a agent? Let us first understand that. Principal, forget about. First, agent, let us understand. Agent is a person. I repeat. Agent is a person appointed by the principal. What is it? Agent is a person appointed by an individual, appointed by the principal in order to act on behalf of principal. Repeat again, simple way. Without applying any law, contract act, etc. Let us not break your head. Simple language if I have to tell. Agent is a person who act, okay, who is appointed by the principal to act on behalf of principal. Means I will appoint a person to act on my behalf. Such a kind of person we call as a agent. So who is a agent? Agent is a person who is appointed by the principal to act on behalf of the principal. Such a kind of person we call as a agent. First one, everyone understood the meaning of agency, clear? Huh? Everyone, faster. Let us try to complete the chapter as soon as possible, so that you will get more revision time. Okay, that's one point. So, who is an agent? Agent cannot act on himself. Agent cannot act on his own account unless principal permitted to do so. Agent can do whatever principal said him to do. That said is there, na? That can be said either expressly or sometimes impliedly. Or sometimes impliedly. Means what? Everything principal need not tell to the agent to do. Certain things has to be done impliedly. Certain things has to be done impliedly. Example I will give you. See here. I am a person who is doing a business of rice. Rice will be there in a rice shop. So we will pack everything in a bag and we will give. Okay. From a very big vehicle, rice came. Huge heaps of rice has come. In normal covers, it came. Are you understanding? One customer came to the shop. My main shop is in, say, example, in T Nagar. I wanted to operate not just in T Nagar, I wanted to operate also in Nungambakam. What I done, I kept you as a agent there. I said, if customer comes, ask them to take a sample. Ask them to take a sample. Let them have a taste of our rice. Once everything is okay, na, ask them to buy the main product. This is what we have said to the customers. Now listen, my agent is there in the Nungambakam. Original branch is there in T Nagar, say for example. Now listen carefully what would have happened. Customer came to Nungambakam branch. Agent is sitting there. He asked, how much is this? He said, sir, for 1 kg, it will be 40 rupees. Okay. Then he said that, then pack 5 kgs and give. Pack is actually in 50 kgs to 25 kgs. 5 kgs, he said. Okay. So what agent is expected to do, whatever principal can do directly, agent is also expected to do the same. Correct? So what agent has to do? Agent has to sell not on his own account. He has to sell on behalf of principal. He has to sell on behalf of principal. Who is the principal here? Principal is in T Nagar. On his behalf, you are selling. So whatever he would have done in his own case, you should do that here. So what I have done, you are an agent. I am the principal. He asked 5 kg. I saw 5 kg bag not there. Then I opened the 50 kgs bag, took the rice, pour it on your hands. I said, take it. 5 kgs or 1 kg or whatever the case may be. That customer got very angry and they started fighting. Now the fight is not among customer and the agent. The fight is among the customer and the brand, the principal company's brand. Adhe problem of always a principal agency. If you go to DMARC, any wrong happened, na, person who did wrong, we will not remember. DMARC remark. If you take, understood? So whenever there is an organization and persons working inside the organizations are there, persons working inside the organizations are not working for themselves. They are working for the company, also called as a principal. Therefore, a principal agency relationship exists. So listen carefully. Now, principal called agent and started scolding like anything. He said, are you a mad fellow or what? How can you give like that? You should pack and give. Sir, you said I can sell in T Nagar. Same you can also do in Nungambakam. But you did not tell that I should put it in a bag and give. Giving in a bag, who will tell you? Are implied? Everything I need not put on paper and tell, do this, do that. You should go in a flow. Agent should have a prudence. Means minimum common sense he should have. Whom? Agent. If you are appointing a agent who doesn't even have a common sense, na, principal will become liable to the outsiders. Mark my words. If agent is not performing well, that is not the mistake of agent. That might be mistake of agent. The first mistake is with the principal for appointing an inefficient agent. Why I am telling all these things is you should know the relationship between principal and agent in general. Okay. So who is a principal? Who is an agent? Means agent is a person appointed by the principal himself to act on behalf of principal. To act on behalf of principal. I will draw one chart. Don't write now. With that chart, you can understand complete concept of agency. Some minor exceptions will come in the middle of the chapter. Those we need to discuss. That's it. Remaining things, directly in the table I will write you. You can understand it very clearly. Okay. See here. Same table, what I am drawing now. Partnership Act again it will come. At the time I will not repeat again. I will tell I already discussed in agency chapter. See here. See here. Case 1. Principal can do something. Agent is expected to do that. Agent has actually done that. Principal is liable to the third parties. Okay. Who is liable to principal? Agent is not liable to principal because I have done whatever you have said. Not applicable. Okay. Or I will write this way. Liability of agent. Liability of agent. Then don't write. I said na. Don't write. Listen first. Case 1. Principal can do something. As per the rules of agency, agent is expected to do that. Agent has actually done that. Now, for the act done by the agent to the third party, TP means third party. Who will be liable? Principal is liable. Who is liable to, what is the liability of agent? No liability. So, not applicable. He has done everything as per the rules. Case 2. Principal can do something. Listen, don't write. Suddenly, if I change a question, unnecessarily you have to strike out an entire chart. I will give time for you to write. At the time, you do that. Principal can do something. Okay. Agent is expected to do that. Sorry. That's why I said don't write. By mistake, I have written another one. Principal is not expected to do something. Agent also not expected to do that. Agent have not actually done that. Not applicable. Not applicable. If act is not done, act is not done, what liability will come? Okay. Next. Number 3. Principal can do something. Agent is expected to do that. Sorry, I will write a different one. That's why I said don't write. In my mind, whenever one thought will come, I will write. Principal can do something. Agent is expected not to do that. Very, very important case. But a principal can do, but principal said to agent, this I only can do, you cannot do. Okay. Principal can do. Agent is expected not to do. And agent has not actually done that also. Very good one. So, who is liable to third party? Principal is liable to third party. No. Agent did not do anything, na? Then how come for the act of agent, principal will be liable to third party? Not applicable. Not applicable. First one is, you should understand the difference between these two. First one, act done by, so see the tick mark there. Act done by agent with a third party, who will be liable? Here, how agent is liable? See, here what we are saying, liable to third party means who will be liable? Principal liable. Then what is the liability of agent? No liability for me. I have done whatever you asked me to do. Okay. Next. So, third one, principal can do something. Agent is expected not to do that. Agent has not actually done that also. So, liable to the third party is not applicable, not applicable. Fourth case. Fourth case. Principal is expected to do something. Agent is expected to do that. Okay, agent is expected to do that. But agent have not done that. This is not doing something wrong. Omit to do something good. Not doing good is also equal to doing a bad. So, principal can do something. Agent is expected to do that. But agent has not actually done that. In this case, who will be liable to the third party? For appointing such a nonsense idiot as an agent who is acting with the third party in a wrong way, principal only will become liable. Who will only become liable? Principal only will become liable. What is the liability of the agent? Liable to the principal. Liable to the principal. So to the principal, he will have a liability. Third party agent will not have any liability. Third party principal is liable. But to the principal, who will be liable? Agent is liable to principal. Means third party will slap the principal. Principal in turn will slap the agent. Directly third party won't slap the agent. That is the logic of this particular concept. Okay. The principal can do something, yes, can do. Agent is expected to do, yes, expected to do. Done, not done, not done. For not doing a correct thing, first third party will slap the principal. Principal will slap the agent. So cycle will run that way. Next one. Number 5. Principal can do something. Principal can do something. agent expected to do. Agent have actually done that. Sir, first case, sir, but done that in a wrong way. Very important. Sir, both are same, na? First case, principal can do. Agent is expected to do. Agent have actually done in the way in which principal wanted him to do. Second case, principal has can do. Agent is expected to do. But agent have actually done, but done that in a wrong way. This is a wrongful way of acting what principal can do. For this also, principal is liable, agent is liable to the principal. Okay, agent is liable to the principal. So, in this case, fifth case, who will be liable? Principal is liable to third party. Principal is liable to third party. But there are some exceptions to this that we will read in the chapter. This is general meaning. Some small changes will come. Those we will see when we go into the chapter in deep. Next, principal can do something. Principal or principal. Okay. Principal can do something. Agent is expected not to do. Third case. But agent have done that. Different from third case now. So 1, 2, when you see both are same, 1 and 3, 3 and 6. Okay, like 1, 5 both are same with a small change. Like that 1, 3, 6 same with a small change. See there. Principal can do something. Principal can do something. But principal said to him very clearly, you don't do that. Okay. Agent acted on that. Means what? Principal can do, agent cannot do, but the agent have actually done that. Even though principal said don't do. In this case, who is liable to third party? Principal is liable. Agent is liable to the principal. Here also there are exceptions. What is that exception? We will see when we go into that. Generally, the idea. Next, seventh case. Principal A cannot do something. Agent is expected not to do. This is similar to second case now. Principal cannot do something. Obviously, agent also cannot do that. But the agent have done. Now, from the second case, seventh case is changing. So, but the agent have actually done that. Now, who will be liable to the third party? Agent A liable to the third party because till the situation where you are doing what principal can do, at least by implied authority, third party principal becomes liable. But in this case, in the seventh case, principal A cannot do something. Agent is expected not to do that. But the agent have actually done that. Now the agent have done what principal also cannot do. Agent only will become liable to the third party. Okay, agent is liable to the third party. And the agent has no liability towards the principal. Normally for breach of trust he can complain. So liable to the agent, what is the liability of the agent? He is also liable to the principal in a different way. Not like a payment of money, there will be a different concept. Breach of trust, breach of agency, pay damages, compensation, those will come. So that we will discuss separately. Up to here, I think everyone, all the 7 points, everyone understood clearly, all the students. Yes, liable to third party means who is liable to third party? That's the meaning. Everyone understood all the 7 points clearly. Yeah. Okay. Write down the concept. Write down somewhere. Have you completed writing? Have you completed writing? Write down. Once you complete writing, I will repeat all the cases one last time. Completed writing? Yeah. See here. Case 1, principal can do something, agent is expected to do, and agent has actually done that. There is only a principal's liability towards the third party. Second case, and the agent is not liable to principal because he has done everything in a right way. No liability attracts, only he will get his commission. Second case, okay, understandable. Third case, principal can do something. Agent is expected not to do that, but agent also did not do that. Good one. So in this case, who will be liable to third party? Agent is not liable to, for the acts of agent, principal is not liable to third party. Normally, principal will be liable for the acts because agent concept is not involved here. Then why the table filling will happen? Then only Koushik Mukhesh doing his own business type. For that, this table is not required. Fourth one, principal can do something. Agent is expected to do that, but the agent have not actually done that. Negligence of the agent. For that, principal has to bear. So principal is liable, agent liable to the principal. Fifth case, principal can do something, agent is expected to do, agent have done in a wrong way, same concept. Sixth case, agent principal can do something, agent is expected not to do as per the agreements, but agent have actually done that. Principal only will become liable, not the agent, to the third party, but the agent is liable to the principal. There are some exceptions to that. Seventh case, principal A cannot do something, agent is expected not to do that, but agent have actually done that. Agent A will be directly liable to third party. For breach of agency, he has to pay damages to the principal. That we will see when we come into the chapter. First of all, everyone, please tell me. Basics learning, we spent around half an hour time to have a strong basics on agency chapter. Everybody understood the concept clearly, yeah? Okay. Now, let us see this. Once completed, I can share. So listen first. Okay, put your mind only on listening part. Writing, all these things you can leave. You know, everything in this chart is a representation of study material in a different way for you to understand easily. See, first one. Meaning of agency. Meaning. Contract Act does not define what is an agency, but defines what is an agent. Okay. Who is an agent? I told na. Agent is a person who will be appointed by the principal to act on his behalf. Read. Agent is a person employed to do any act for another. Another we call as a principal. To represent another in the dealings with the third person. So, in dealing with the third party, instead of me, you go and do. That's called as a agent. See, the person for whom such act is done is called as a principal. Person who is doing it is a agent. Person for whom you are doing it is a principal. Okay. First of all, everyone understood the meaning clearly. Step by step, I will ask you. You put yes or no, then we will continue to the next one. Let's not waste time. Okay. As soon as possible, let us complete this. Next. Agency is a comprehensive word which is used to describe relationship that arises where one person is employed by another in order to bring latter into legal relations with a third person. Means principal, agent, third party. Principal, agent, third party. What is saying? Agency is a comprehensive word which is used to describe a relationship that arises where one person is employed by another. Agent is employed by principal. Okay, agent is employed by the principal. Okay, agent is employed by principal to bring the latter means the principal, into the legal relation with the third party. Means, for example, Koushik Mukhesh is having a business in Hyderabad. He wanted to establish a business in Chennai with the customers in Chennai. He wanted to do business there. I put a person in Chennai as an agent. Means I wanted my agent to have a legal relation with their customers, sir, or I have to deal. But to deal with them directly, I need one person. That's the agent. That's why always I said in the table, act of agent, principal becomes liable. That's why where one person is employed, agent, by another principal, agent, principal. Principal is the latter here. And in a sentence, when I say lion and tiger, and the latter one means the tiger, agent and principal, and the latter means principal. So, employed by principal in order to bring latter means principal into legal relation with the third person. Legal relation with the third person. That's why in 90% of the cases, principal A will become liable to the third party, or no one will become liable. Agent rarely liable to the third person. Next. Rule of agency is based on a maxim. Maxim means a statement in Latin. Okay. The word maxim is quid facit per ilium, facit per se. You need not remember as it is, just you remember. What does it mean? He who acts through an agent is acting himself. Means what? I am stopping myself from doing something and I am asking some other to do. I am stopping myself. Now, stop it, they call quit. Okay, quit. Quit what? Quit. I am quitting myself. My face I am not showing. Facet per se means a face. My face I am not showing. Okay. Alium means another person in Latin. Facet per alium means instead of my face, I am showing some other face to the third party and getting the business. So the rule of agency is based on a maxim: quid facet per alium, facet per se means I am not showing my face per se, but I am making other person to see, and that person will be doing business on my behalf. That's the meaning. So that translates to a general English as under: he who acts through an agent is acting himself, or himself acting. Means what? For the act of the agent, principal becomes liable. That's the meaning of this statement. Next one. Test of agency means how can you tell that relationship between two persons is agent and principal? Why can't it become employer employee? Why can't it become master and servant? Why can't it become a company and a directorship type? Why can't it become bail or bailee? Why can't it become any partner relation? How can you tell that this is agency? What is the test? There are two tests to call something as a agency. Where the person has, I repeat, where the person has capacity to bind the principal means for the act of him, principal should become liable and make him answerable to third party. Adhe kada concept. Ante table, what is the concept? Act is done by agent, but principal is becoming liable. So, where the person, agent, has a capacity to bind the principal, and make him and a principal answerable to third party. Answerable to third party, obviously, that's what I said. And where he can establish privity of contract between principal and third party. See, contract act, there is one concept. Unit number 3, it will come. Privity of contract. Unit 2 also it will come. What is this privity? If any person inside the contract has to get any rights, he should be a party inside the contract. Sir, I did not understand. General contracts, when we discuss, I will tell about this. Now I don't want to waste time, but I will tell a simple way. Two parties are fighting. Unrelated party, being a third party, came and said that you are right, you are wrong. Immediately we will tell that shut your mouth and leave. You are not a party to the dispute. Adhe privity. Whenever someone has to become liable to contract, he should be a person inside the contract first. Now question. Agent is selling goods to third party. And if principal is not known to the customer, third party. But still, customer ki principal is liable. Means principal A will be liable to the third party being a customer, not the agent, though privity does not exist. Though privity, that's why it became a special contract. Generally, no privity, there is no liability. But here, even though there is no privity, agent is creating a privity of contract between third party and the principal. That's what he wanted to tell. So what are the two essential conditions making an agency? You should have a capacity to bind another person for your acts, and you should make him answerable to third party. Your agent is a principal. Second, establishing a privity of contract between principal and a third party. And the third party. If the answer to these questions is yes, then there is a relationship of agency. Next. Is the meaning of agency. The main segment completed. Now we are going into essentials of a agency. What is it? Essentials of a agency. There are 4 essentials. First, I will show you what are the 4. Basis, consideration, capacity to be employed as a agent. Let us see. Basis of agreement. According to the definition under section 182, an agent never acts on his own. That's what I said very clearly. Agent should not act on his own account. Agent should act on behalf of principal. Very good. Next. He either represents his principal in any transaction or dealing with a third party, or performs an act for the principal. Agent cannot do anything on its own. He will do only for the principal. In either case, the act of agent will be deemed in law to be not his own, but of the principal. That's why act of the agent becomes the act of principal. Classic example, shall I tell you? Insurance agents are there. Insurance agents. They will come. They will collect money. Now, insurance agent collected money, LIC collected money. LIC, we will tell. Hey, for example, insurance agent came to you. He said, sir, give the check for this month, 30,000. You gave 30,000 check for LIC. Okay, you gave 30,000 check for LIC. The moment you give 30,000 check for LIC, what will happen automatically? 30,000 check the moment you give to the insurance person, he will deposit with the insurance company. Insurance company will get the money. Okay, now I ask you what you did. I paid insurance policy to the insurance agent. You will not tell. I paid insurance policy to LIC. Why? Money given to the agent becomes the money given to the principal because of this. Next. Consideration not necessary. Sir, what is this? See, agent generally gets a commission for the act done. However, if the principal and agent are father and son, or there is a relationship exists, okay, don't call it a social relation. Chapter number 1 of the Contract Act. This is a commercial contract, but consideration is not there. That's why these form part of special contracts. So in a contract of agency, agent may not charge consideration sometimes. Agent may not charge consideration sometimes. This is because of 2 reasons. Number 1, there might be some social relation between both of them. That's one reason. Second reason is sometimes consideration may not be paid by law also. Example, partner to a partnership firm is a agent. Partner to a partnership firm is a agent. But partnership act, what they will tell, if partnership deed nothing is there, agent is not liable to take any remuneration. Means no payment to the partner as an agent for the work done. So therefore consideration is not there, still he is an agent. So therefore there are so many circumstances where agent may not charge consideration. So the peculiarity in the law of agency lies in the fact that unlike other forms of contract, means different from other forms of contract, consideration is not necessary. According to the definition, an agent never acts on his own, but on behalf of, but on his own behalf, but always works on the behalf of another. Even then, he may not charge consideration. Next, capacity to employ an agent. Who can employ agent? Principal. That principal should be major, sound mind, everything. So an agent never acts for his own, but acts on the behalf of principal. Sorry, this line you have to change here. By mistake, it was rewritten the same way. Capacity to employ agent. Principal should have a capacity. Who should have a capacity here? Principal should have a capacity to do that. So principal should be a major, principal should be a sound mind. All these points should come. By mistake it was there. I changed in the original charts already. Next, capacity to be employed as an agent. So who can become agent? Any person can become agent, even minor and unsound mind. Sir, unsound mind, he will do some mistake with the third party. Yes, principal should have that common sense that I should not put a minor because minor will not become liable. I should not put an unsound mind as an agent. If he does something, I will become liable. If principal is so negligent that he doesn't even care about what is happening, then you can have. See, between the principal and the third person, any person can become an agent, irrespective of whether he has a contractual obligation capacity or not. But a person who is not of the age of majority and sound mind cannot be agent so as to responsible to his principal. Sir, I did not understand. I will tell you. First, read it. Basics of my table, if you understand, half the chapter will be completed. Means this is the meaning. Okay. So see here. What we said, can a minor become an agent? Yes. Can an unsound man become an agent? Yes. Then what will happen if he does some wrong? Na? Third party principal will be liable. Unnecessarily, why you kept a minor and why you are feeling bad? Why you kept unsound man and why you are feeling bad? So responsibility is with the principal if you are appointing a wrong agent. But the problem is in the table what I said. In the table what I said. Third party principal is liable, but to the principal, agent will become liable or not. That liability will not get attracted if minor or unsound mind is there. Example, you kept a minor as a agent. That minor has done some mistake with the third person. Third person will sue the principal. Principal will pay him. So slap on principal's face. Now principal will slap whom? Agent. You cannot slap because slapping a minor becomes a crime. Adi, that's the point he wanted to tell. So normally, if he slap you, sir, here slapping represents suing. Like that, you should understand, not really slapping. So third party will slap the principal. No, principal will slap the agent. But to slap the agent, you can slap only when the person is capable of getting slapped. But the minor is not like that. No, you can't slap a minor. You can't slap a person of unsound mind. So at that risk, if you want to appoint, you appoint a minor as an agent or unsound mind as an agent. Later, you will become unsound. Next, even minor can become an agent and principal. Okay. And the principal can be bound by his acts. That's what we said. Na? That's if agent happens to be a person incapable of contracting, then principal cannot hold the agent liable. In that case, principal is liable. In case of any misconduct where agent has been negligent in performance of the duties. First of all, everyone has to give me one answer. We completed two important concepts: meaning completed, essentials completed. Are you all really thorough with the concept? Number one. Next one, did every concept whatever we read is taken from the table what we discussed at the beginning or not? I'm putting it before you. I'm putting the chart before you. Now read and complete it. Fastly revise everything. So here there is a small error. It was rectified in the main edition. We continue. Okay. Enough time I have given for you to read. Now, let us concentrate on the next area, modes of agency. Modes of agency. Listen. See the screen. Next segment is modes of agency. Two sections, 186 and 187. Both together we are going to discuss. What is the name of the concept? Modes of agency. These are all the things we are going to read in modes of agency. Okay. Ratification, all these things. Then we come to extent of agent's authority. Then the concept of subagent and substituted agent will begin. What is it? Subagent, substituted agent. After that, difference between subagent and substituted agent. Rights and duties of agent. All these things, rights of agent, duties of agent, liability towards the third party, rights of the third party. When to terminate agency, irrevocable agency. These are all the flow of areas we are going to discuss one after another. Okay. Now see here. Today in the class, we are going to first start with the modes of agency now. One by one, please concentrate properly. Listen to the discussion in the chart, more than enough for your examination. One by one. Express authority. Agency created by express authority. Sir, what do you mean by express authority? Express authority means A says to B clearly that I can do this. You do this on my behalf. If A says B like that clearly by expression of words or by doing an agreement, we call it express authority. Okay. The authority of an agent may be expressed or implied. An authority is said to be expressed when it is given by words, spoken or written. Spoken or written. So, the authority of an agent may be expressed or implied. An authority is said to be express authority when it is given by words, either spoken or written. Either orally A said to B, do this on my behalf, I will pay you something, or they enter into agreement directly. This we call as a express authority. Okay. Example I have given you. Anil is residing in Delhi and he has a house in Kolkata. Anil appoints Soham by deed called power of attorney as a caretaker of his house. Agency is created by express agreement. Express agreement. See, Anil has a house in Delhi and Kolkata. Kolkata house is vacant. Someone has to take care. Na? I appointed one person to take care of that on my behalf. Normally, I have to take care. I am appointing you. You are an agent now. Express authority. Next. Implied authority. Just now I told you. Implied authority means agency sometimes will be created by implied authority. When agency will be created by implied authority? Let's see. An authority is said to be implied when it is to be inferred from the circumstances of the case, and things spoken or written or ordinary course of dealing may be accounted circumstances of the case. Sir, I did not understand. Read once. After that, we will go into a good example. Read first. Okay. Okay, ba? Okay. Now listen. Listen. I will give you two examples. Okay, I will give you two examples. You try to understand that properly. Okay. Point number one. Point number one. Agency created by express authority we discussed. Now, agency created by implied authority, let us understand. See, there is Mr. A in Chennai. There is Mr. B in Hyderabad. Okay. A kept B in Hyderabad to manage his business, not as an agent, to manage his business as a manager. Okay, employer, employee. Okay, next. Always A used to tell to B, sell the goods to persons in Hyderabad on my behalf. You do the business as if you are the owner of that business. Monthly tell the sales, transfer to my account. I will pay you some commission on that. Understood? Now, though you appointed the person as a manager, the whole ecosystem is looking like an agency. That's what he wanted to tell. Means what? Though name of the appointment is expressly not an agency, but the entire ecosystem, when you see, there is a person, there is another person. This person can do something. This fellow in the name of manager is doing all those things on his behalf and get a commission on whatever he has done. Though by express words, nothing is there, still there is a agency, because this is a agency by an implied authority. Means what? Nothing is said by words, but the way in which you are acting gives rise to a feel that there is a agency. That's why what he said, words you have to write properly in exam. What is an implied agency or agency created by implied authority? An authority means a power, is said to be implied when it is to be inferred. Inferred means understood from the circumstances of the case, means from the events happening in the case. A is sending goods to B. B will be selling them in Hyderabad. That too on behalf of A. For that he will get commission. All these circumstances, when I see, I can understand that there is a agency here. That's the meaning. So, and the things spoken or written or ordinary course of dealing may be accounted to the circumstance of the case. Means daily you will be doing transactions now. On that basis, I can account for, means I can understand that, I can take for granted that there is a agency. Okay. For that, one example is also given. Later you read example. Don't waste time now. I gave example now, that you follow. Everybody answer. Understood the concept of implied authority clearly? Yeah. Everyone understood the concept of implied authority? Okay. So, in a implied authority, by words or by written form, I won't give any authority. But the circumstances of the case are in such a way that I can understand that there is an implied authority. Understood? So, see, most of the times, we may not understand whether one person likes another person or not. By the way they act, we can understand that something is going on between those two. Means expressly one person may not tell to another, but the circumstances of the case will make you feel that some relation is going on between two people. Hey, everyone, yes or no? Though expressly one person may not tell to another person, from the circumstances of the case, we can understand something kirikiri is going on. Or no? So, most of the times implied works well in life. So, express, so many people may not tell, but impliedly they will express. So, I implied. Now, everyone understood the concept, sir. Implied authority, you can skip, sir. Next concept, you can go. We understood that very well. Practically also I understood. So, that's the main idea behind. So, certain times, expressly you can't tell that, yes, there is an agency. But from the circumstances of the case, when you see that the behavior of the person makes you feel that something is going on. So, the other logic behind this. Next. Agency created by necessity. Agency created by necessity. Sir, I did not understand, sir. What is this agency created by necessity? Question will arise that. Let's read. An agency of necessity arises due to some emergent circumstances. Due to some emergent circumstances. Let's read first. In emergency, a person is authorized to do what he cannot do in ordinary circumstances. Thus, where an agent is authorized to do a certain act, and while doing such an act, an emergency arises, he acquires an extraordinary and special authority to prevent his principal from loss. Sir, I did not understand. That is the agency created by necessity. What is it? Let us understand. First, read the content. Example, don't read. I will give super example than this. First, read this content clearly. Okay, let me explain what is this. See, reading will complete only half, but understanding completes the balance half. Agency created by necessity. Okay, agency created by necessity. See, there is a person A. A is in Chennai. A is in manufacturing of, say for example, cotton. From the raw cotton, they will make cotton cloth. Okay, cotton cloth. Who will make? A in Chennai. He has a factory. He started a similar factory in Hyderabad also. He kept Mr. B as a caretaker of that factory. Okay, he said that take care of that factory. Whenever there is a problem, you let me know. Okay, and factory activities should go on according to my instructions. I will give you. You will do on my behalf. So what is their express authority? The agency is already created between whom and whom? A and B. A is in Chennai. B is in Hyderabad. Okay, B is a agent, A is a principal. Clarity. So B will be doing all the things in the factory on behalf of the principal. Payment of salaries to workers, recruitment of new workers, removal of existing workers, increase in salary payments, distribution of machinery, taking care of everything. What principal is doing in Chennai, bit by bit, each and everything agent also can do in Chennai, Hyderabad. This generally agency is created between both the persons. Up to here, everything is calm going, everything is clear as well. Now started a problem. So there is a agency already existed. One day, factory la cotton na, it catch a fire. Everything in the factory is getting burnt. Immediately, I need to bring fire station people to enter into the picture. For that, I need to spend 5 lakh rupees immediately. Then only they will come. Immediately, I call the fire fighting persons. Everyone I call. Immediately, I call them. They said, sir, that much big factory means it will cost somewhere around 5 lakh. Immediately, agent is there, na person who is taking care in Hyderabad. He said, no problem, I will give. Immediately, he transferred 5 lakh rupees to them. Said that, please, come and do that. Immediately, 30% of the factory only burnt in fire. They shut everything. And B has done great job. Now, B spent 5 lakh rupees. Normally, agent can do all those things. No, agent will do what principal can do. But agent sometimes in emergency situations will do certain things even out of his scope. Even out of his scope. But he will do that. Respectfully, agency by necessity will be created now. Means you are already a agent. Yes, sir. Now, for the agency, there is an express authority. Yes. In that express authority, calling a firefighting persons and pay 5 lakh is there. No. Even then, you will get commission for the sale and also compensation for what you paid, because there is an agency created by a necessity here. That's the agency created by necessity. Emergency situations, when an agency is created between two people, we call it agency by necessity. Principal is liable to pay whatever emergency payments that are made by agent to a third party. Here, an agency of necessity arises due to some emergent circumstances. Fire. In emergency, a person is authorized to do what he cannot do in ordinary cases. Generally, you cannot pay 5 lakh to some other person and reimburse from principal, but emergency case you can do. Thus, where an agent is authorized to do certain act, and while doing such an act, an emergency arises, he acquires extraordinary powers and to prevent the principal from loss. See, if I don't call that firefighting person and spend 5 lakh, 5 crore worth of goods will get spoiled there. So at that time, what principal will tell? Agency is negligent. He is looking like a cinema when something is happening. Like that, you will scold me. If I do that, you are telling that 5 lakh rupees why you spend without asking me. No, agency by necessity will be created. Everybody listening to the live understood the concept clearly. Okay. Next. Agency by Estoppel. Do you know what is an Estoppel? Estop means cannot stop. Okay, Estoppel means cannot avoid. What is it? Cannot avoid means agency that can't be avoided. Agency that can't be avoided. What is this agency that can't be avoided? Let us understand that clearly. Okay, let us read. Let's read. An agency by Estoppel is based on a principle of Estoppel. According to Section 237 of Contract Act, an agency by Estoppel may be created when the following essentials are fulfilled. Okay, when Estoppel will be created, these conditions, 5 conditions are there, 1, 2, 3, 4, 5. Those 5 you need to fulfill. Condition number 1, principal must have made a representation. The representation may be expressed or implied. Okay, that means principal have kept some person as his representative. That representative is appointed either by express or implied. The representation must state that agent has an authority to do certain acts, although really he has no authority. The principal must have induced, means forced the third persons by such representation. The third person must have believed the representation and made the contract on the belief of such representation. Sorry, one word also I did not understand. That's why I will keep it before you. Please read this point and this 5. Read it. First, you put your efforts in reading. After that, I will explain clearly, like in the previous points. Okay. Now, I have given around 2 to 3 minutes time such that you will read 4 5 times. Such that you will get word to word what is the point you wanted to convey. Okay. I will explain this with an example. See here. Please see here. There is a business. Owner of that business is Mr. A. Mr. B is his friend, who is a cashier, normal cashier, getting some 30,000-40,000 per month. And cashier and some other things also he will do in the business because of being a very good friend to him. There are customers. There are customers. Now listen carefully. Owner has to buy directly from the customer, sir. Owner has to sell directly to customers, sir. Yes. One day what happened? Listen carefully to the point. There are customers. There are suppliers also. There are suppliers also. Whenever customers come to the owner, owner used to tell, don't come to me, directly go to B. He will give you the goods. He will give you the goods. Same thing. So the suppliers also, owner used to tell, don't supply goods to me. If you supply to my friend, he will give to me directly. Give it to him. He will give it to me. This is what he said. Means, to the customers he said, you want to pay? Pay to him directly. You wanted to buy, sell the goods, sell to him, he will give to me. Now, there is no agency created between A and B in any kind. Express illa, implied illa. Only to the third parties. A is representing B as his agent. Okay? And forcing outsiders, inducing the outsiders to believe that he is a representative of A. Understood the point or not? He is a representative of A. Okay, now who is a representative of A? B is a representative of A. Now what we should do? B should deny that and say that no, he will talk like that only. I am not any agent here, I am only a cashier. Just as a friend, I am doing the work. Like that, who should tell? B should tell to outsiders. B is silent. A is also silent. Okay, A said to the outsiders that B will be taking all the things. Means by conduct of that person, by behavior of Mr. A, outsiders will understand, they are forced to believe that B is a agent of A. If we can give to B something, it is as good giving to A. One day, believing in the fact that B is the agent, some suppliers have sold goods to B. Some suppliers have sold goods to B on credit. For that credit transaction, A will become liable. A cannot say no because now B has become an agent by Estoppel. Now you cannot stop outsiders from believing that B is your agent. Credit purchase is made by B. A only have to make the payment because he became an agent by Estoppel. Now read the circumstances here. Everyone, have you understood the logic of this particular section up to here clearly? Implied contract directly principal agent between relation is created. Here principal is telling to third party that he is a agent, because of that agency is created. Implied two parties, but Estoppel, because of the third party belief you became an agent. See, now I will link the example what I have given to the case or to the points here. See here once. What I said, really there is no principal agency relation existing between whom and whom, principal and the agent. Actually, there is no. But A always saying to the third party that pay to B, B will give to me, receive from B, it is as good you are receiving from A. When you going on telling like that, people will start believing that B is your agent. Later, you cannot stop outsiders from believing that B is your agent. That's called as estoppel. Okay, see here. Principal must have made a representation. In my example, Mr. A is always doing a representation. Okay, that representation can be expressed or implied. The representation must state that agent has an authority to do certain things. Always he's telling that you wanted to buy from B. You wanted to sell to B. Now you are doing as if B can do the act of buying and selling on your behalf. The principal must have induced, means forced the third person by such representation. Third person believed in that representation, made a contract with that particular B. For that, A will become liable because B has become an agent by estoppel. Everybody understood the concept clearly? Everyone should answer. Okay, next. Next one. First, everyone tell me up to here, all you all having a full clarity. Can we move on to the next one? Yeah. Next issue. Agency by ratification. Agency by ratification. Ratify means what? Let us understand first. Okay, on that I will first explain you some points. Ratify means subsequent approval. Okay, sir, I did not understand. I will give you a basic ground level example first. On that basis, you apply for agency as well. Okay, subsequent approval for what is a question. Let me explain. There is a kid, maybe at fifth standard or sixth standard. Okay, hardly the age is 10, 11 years. Every day there is a pattern at his home. He will come from the school, throw his school bag to one corner of a room, go for play. Tiredly, he will come back to home, has to do his homework and some basic study, and then he has to sleep. Next day, repeat again. This is a pattern going on in his home. Assessment test will be conducted in the schools. First assessment test conducted, unit test, assessment test they call. So in that assessment test, he did not perform well. In a total strength of 50-52 students, he is in somewhere around 10-11 stage. Parents were unhappy. They wanted to go back and extrapolate where mistake has happened. Then they came to know that after school, he is not directly studying, he is going for a play, because of which he is becoming extremely tired. After that, he could not do anything at home. This is what they believe strongly. This is the mistake where we are going wrong. They wanted to rectify this. They wanted to what? Rectify this. Then what he said to their son? They said very strictly, from next day onwards, after the results came where he couldn't perform well, they said very strictly to him, every day, come from the school. Physical activity is important, but not beyond the education. That's the mindset of their parents. Good for them. So, what they said very strictly, come every day. After coming, get yourself fresh, half an hour time. 4 o'clock, you will come back. By 4:30, you should be ready for study. 4:30 to 6:30, complete everything. After 6:30, you play up to 8:30, no problem. come, have some food, sleep. This is the pattern they made at home. Understood? One day over, he's following that. 2 days, 3 days, 1 month completed. Strictly he followed. One day, he came out from school, he thrown the bag, he first went for a play. Okay, first went for a play. Later, he came back and studied a little bit after getting tired and he slept. Parents came to know, or his dad came to know. Okay, now two options are there for his dad. Option number one, he said, no problem. 1 or 2 days, nothing will happen. Generally, what you have to do, you have to first to do study and then you have to go for play. One day you have done reverse. Act done is valid. Playing is in our scheme. Study also is in our scheme. Act done is valid. The way in which he has done is not valid. One after another he has to do, but he has done reverse. Then they said, okay, no problem. One time na, we are giving approval for that. No problem. You have first done this and next doing that. Na, you should have asked us before. You did not ask anyway. You have done. One time now we are pardoning. We are showing some mercy. No problem. We are giving approval. This is called as ratification of a defective oblique. Means what? Whenever there is some act done in a defective way, it done in a wrong way, principal can ratify them. Principal can what? Ratify them. So ratification means originally in our agreement it is not there. Because of my yes now the contract is created. Second, what dad can do, he can become furious and slap him and said, go to home, never again do that. Like that he can do. Now he is not accepting that small defect also. Now listen carefully to the screen. Acts done by the persons can be of two types. Okay, can be of how many types here? Two types. Acts done by a person can be of two types. Type number one, act. Okay. Irregular, illegal. Illegal is always void ab initio. Ratification not possible. When Kshama will be there, when mercy will be there, when we will leave, okay, poda, no problem, one time, when we will tell, when something which is done may be right, but not done in a right way, then we will tell, okay, leave for one time. Murder I have done and said, one time only I have done. One time and half time also mistake. So at that time there is a illegality. One time only he committed murder, na, leave. Next time onwards he will do murder in a proper way. Like that no one will tell. Illegal is always void ab initio. There is no question of ratification. When ratification will come, act done is valid. The way in which they have done is not valid. Na, then subsequent approval ki chance is there. Understood? So now the acts done are not illegal. The acts done are irregular. Acts done are irregular. When the acts done are irregular in nature, then again two partitions will stem out. When act done is irregular, two partitions will come. Ratified, not ratified. First act done is irregular, na? Void or valid? Voidable. Voidable means what? It is not completely valid. It's not completely void. It is somewhere in between both of them. Okay. A contract can start as, listen to my language first. A contract can start as valid, voidable, void, but can end as valid or void only. Voidable ending will not be there. Voidable should turn either into valid or into void Okay. Now listen carefully. Irregular. Act done is irregular, not illegal. Act done is valid. The way in which they have done is not valid. There is an irregularity. Now, if the other party on whom that irregularity done took it very light, he said, okay, no problem. For this, I am accepting. Means he is ratifying the voidable act. Now, voidable will turn into valid. Next, he said, I will kill you if you do again. Now also I am not agreeing for this. Now, not ratified, voidable will turn into void. Now apply the same principle in case of agency. A is a person. B is a person who is not an agent to A. But B has done what A can do on A's behalf directly without asking him. Okay, without asking whom, without asking A, B has done some act on behalf of A. I am not an insurance agent. I am not an insurance agent. I went to some other person's home and said that I am from LIC and I took LIC premium. And promptly I came to LIC and gave money to LIC. LIC point of view, shall I tell na? If LIC says, okay, anyway you collected na, give it to me. If I say that way, then what will happen automatically? I am taking money from LIC. I am taking money from public and giving to LIC. LIC is accepting my act and said that, okay, from tomorrow you become an agent. Now I am ratifying your act. I am ratifying your act. Then the money collected by the agent, LIC will become liable. LIC said that I will kill you and I will file a criminal complaint against you. How can you collect money from public without asking me? Like that, it became serious and said, we don't want that money. Now your act of irregularity is not ratified. Now the point is, since there is no ratification for the act done, agent only will become. A person who is believing that his agent is there, that person only will become liable. This is called as a ratification, and we are now going to read the agency by ratification. Everybody, please confirm. Did you all understand the concept clearly or not? Everybody understood or not? Everyone participating live, give a reply. Understood all the points. See here. Okay. See, agency by ratification. Agency by ratification. Rights of a person as to the acts done for him without his authority, effect of ratification. Okay. Read. Very, very important for exam. Very, very important. Where acts are done by one person on behalf of another. Act done by one person on behalf of another, but without his knowledge. Just now I told na, he don't even know that he has done. LIC don't know that the agent is collecting money or authority. He may elect. Elect means he may choose. Okay, in LIC in our example, may choose, may elect. Elect means it can have options. What options are there? Either to ratify or not to ratify. Dissolve. If ratifies, it will follow as if they have been performed with his authority. If LIC accept na, LIC becomes liable. Okay. So essentials of a valid ratification. Ratification may be expressed or implied. Ratification may be expressed or may be implied in the conduct of the person on whom the acts the behalf are done. Ratification may be expressed or implied. Ratification may be expressed or may be implied in the conduct of the person. Sir, what do you mean by this? See, LIC has, LIC, a person has collected money saying that he is LIC agent. LIC comes to know about it, took money. It did not say anything, no. Now your silence is taken as an acceptance. Second, it said that, okay, no problem. One time you collected, we are not stopping you. Give that money, we will create a policy on that. This is express. Second one is implied. First one, what I said is implied. Means what? Some person saying that he is an LIC agent collected money and brought to LIC. LIC said that, okay, tomorrow onwards we will give you LIC agent position. Okay, then it is a express. Second, they took money and they did not tell anything no to that person. Now, impliedly they are accepting this ratification. Okay. Knowledge requisite for valid ratification. No valid ratification can be made by a person whose knowledge of the facts in the case is materially defective. Okay, materially defective. Read the points once. Okay, I gave an example. A has an authority from P to buy certain goods at market rate. A has an authority from P to buy certain goods at what rate? Market rate. He buys at a higher rate, but P accepts the purchase. But P accepts the purchase. Afterwards, P comes to know that goods purchased by A for P belong to A himself. The ratification is not binding on P. Sir, I did not understand. See here. Important, that's why. Wherever there is a difficulty, put mind on that. No valid ratification can be made by a person, means by a principal, whose knowledge of the facts of case are materially defective. Everything you should know, then you have a right to ratify. You have no knowledge on what are the facts of the case, then you cannot ratify. What does it mean? A has an authority from P, and P gave authority to A to buy certain goods at market rate. Okay. A has an authority. P gave authority to A. Principal gave authority to agent, saying that you can buy the goods on my behalf at market price. He buys at a higher rate, but P accepts the purchase. Who buys at a market higher price? A bought at a higher price and said that, sir, 100 rupees you sent me to buy, but I bought at 120 rupees because there is a scarcity. Believing in that, P accepts the purchase. Now ratified his mistake. Actually, you should buy only up to market. You bought higher than market. Mistake is done. I am okay. Saying that, okay, in the course of business, sometimes it happened. He ratified it. Afterwards, P comes to know that goods were purchased by A for P belonging to A himself. Means what? A did not purchase from market. Those are A's goods only. He purchased for himself long back, and he is now saying that I purchased at a higher rate. Now the ratification will become null and void. Null and void. And who will become liable? Agent will become liable. Okay. However, the principal is prepared to take the risk of what the purported agent has done, he can choose to ratify without full knowledge of fact. Even then, you wanted to ratify, now you can ratify. If you do not accept that, this will come. Next one. Effect of ratifying unauthorized act forming part of a transaction. Effect of ratifying unauthorized act forming part of a transaction. Okay. So the effect of ratifying unauthorized act forming part of a transaction means, see this. There can be ratification of an act in entirely or its rejection in entirely. The principal cannot ratify a part of transaction which is beneficial and reject the rest. Means either full transaction you should accept, or full transaction you should reject by non-ratifying. Ratifying only 30%, not ratifying balance 70%, that concept will not arise. Next. Ratification of unauthorized act cannot injure a third person. I repeat, ratification of unauthorized act cannot injure a third person. What does it mean? An act done by one person, I repeat, an act done by one person on behalf of another without such other person's authority, which if done with authority would have the effect of subjecting a third person to damages or of terminating any right or interest of third person, cannot by ratification be made to have such effect. Sir, I did not understand. Read this first exam question. So I will give you a good example and explanation as well. Read it first. Okay, read the point at least. Let's see. Ratification of unauthorized act cannot injure a third person. Cannot injure a third person. Sir, what is this ratification of unauthorized act cannot injure a third person? I gave one example. Read this. A holds lease from B. A holds lease from B. Terminable on 3 days notice. Means what? A is holding a property on lease from B. B gave his house property on lease to A. You can terminate that lease by giving a 3 days notice, and a prior 3 days before you should tell and you can terminate. C, an unauthorized person and irrelevant person gives notice of termination to A. Notice of termination to A. C, you can understand it in two ways. A holds a lease from B. Let us, in my example, what I have said, B is the owner, A is the tenant, lease tenant. Or you can also take reverse also. A holds lease from B. A holds lease from B. Means what? You can also, in example, we have taken that A is the lessor, B is the lessee. So what happened? C, an unauthorized person, okay, unauthorized person gives a notice of termination to whom? A. The notice cannot be ratified by B so as to be binding on A. Okay, so as to binding on A. See, point is, if at all ratification has to be done, it should be done by any of the parties to the contract. A third party's mistake should not affect one of the party in the contract. On this, there is one another big question that came in exam. At the last, it will come. That's why I'm not asking you to read it completely. Just to remember that a third party cannot put any of the persons into a wrong position just by doing a ratification. Sir, I did not understand this part clearly. There is a linking part at the last part of agency chapter. Then I will explain it clearly. Other than this, you read the remaining parts now. Ratification must be done within reasonable time. Means what? If act is done now, not 10 years after, you should not do ratification. It should be done within the reasonable time. Not just ratifying. Communicated to the other person that you ratified, either express or implied. Okay, act to be ratified must be valid. That's why I told you. Murders, illegal acts can't be ratified. So act to be ratified should not be void or illegal. Should not be void or illegal. It should be legal and irregular, not illegal. That's it. With this, we completed first part of the agency chapter. First part, there are 3 parts. In that part 1 is completed successfully. Everyone in the class, please give me one reply. Understood the agency topic up to here clearly, yeah? Yeah. Ratification of that part you leave, because I wanted to explain that in a deep manner another way. So that's why I'm just reading that and I left the 200 section. Remaining, you must be completing. Okay. Next one. See, I will be covering up to here now. So let me cover the extent of agent's authority. Means what are the rights, powers of an agent. Okay. So here I will read, we will complete. Again, rights of the agent place will come. Another answer. At that time, I will not spend time. I will cover here itself in depth. Extent of agent's authority. What is the powers of an agent? The authority of an agent means capacity to bind the principal to the third party. Just to be written, act done by the agent, who will become liable? Principal is liable in 99% of the cases. The agent can bind the principal only if the acts are within the scope of his authority. Means principal cannot do something. Okay. Means agent also cannot do. That means it is not within the scope. At that time, we cannot make principal liable. Already we read in the basics chapter or not. Everyone in the class, please answer. Already had we read that or not? Everyone. Yeah. That's why my chart, if you read that the first box, agency, the first clarity will not be missed. Wherever you read, meaningfully you will read. So first point, completed. So agent can bind third party, agent can bind principal to the third party. Done. But provided the act done should be within the scope of his authority. The extent of agent's authority, whether expressed or implied, is determined by. Means what? What are the powers of agent? What agent can do? How it will be decided? You are saying it should be within your authority. What is my authority? You tell me. that will be divided into three parts. Number one, the nature of the act or business he is appointed to do. For example, construction business look you entered. Generally, what an agent is expected to do in construction business, cement, recruitment of labor, facility of water to the construction, all these things relating to the construction, software development, pharma, medicines manufacturing will be my authority. Yeah. So nature of business will give the powers to the agent. Number one. Number two, things which are incidental to the business are actually done in the course of such business. Generally, nature of business, different things they will do. Okay, those things. For example, say take the same construction business. Whenever labor is not coming every day regularly, we will recruit a new part of labor into that. The part of normal real estate, we will do that. So that you can do again. And separately, principal need not tell there should be 100 workers working on a building. 90 will come one day. What you have to do? Normally, what in construction they will do? They will recruit another 10. That is the general implied power given to the agent. Next, usage of the trade. Generally, in the trade, whatever you do, you can do that. And in general, if you have to tell, nature of business will decide what is your authority. Incidental to the business, they will decide. Or general usage in that trade, they will decide. Agent's authority is governed by two principles. Not principles means rules. Agent's authority in normal circumstances, emergency. Hey, emergency we have already completed. First let us read emergency. He has an authority in an emergency to do such acts. We read na of agency, one agency. Forget every necessity. So normal agency is there. Along with that, emergency also can occur, and an agent by necessity will be created. So he has an authority in an emergency to do all such acts for the purpose of protecting his principal from the loss as would be done by the prudent person in his own case under similar circumstances. Means what? For protecting the principal against the loss, whatever a person of a normal mindset will do, all that you have done, you have a right to get all those things, and you can get back all reimbursements from your principal. Already we read that. Agent's authority in normal circumstances. An agent having an authority to do an act has authority to do every lawful thing which is necessary to do. Okay, every point by point he need not tell. Lawfully, whatever I can do, all those things you can do. Sometimes even beyond your powers you can act, but there should be an emergency to do so. Emergency to do so. Whatever be the nature or extent of agent's authority, it will always include the following. Every lawful thing is necessary. Every lawful thing justified in the customs of trade. In an emergency, same point again. Next. Now, question will arise. Sir, you are saying emergency, sir. Well, how can I tell something is an emergency? When agent can be called as agent in necessity or emergency, when can I tell? Normal circumstances I can understand. Principal and agent will agree to certain terms and conditions. Agent lawfully will do all. That I can understand. Emergency means what? What you can call something as emergency? Clear? See, some small emergency came. You can tell to principal and do, but you did not tell him. Directly you have done. So now question arises, what is an emergency? To constitute a valid agency in an emergency, following conditions should be satisfied. Agent should not be in a position or have an opportunity to communicate with the principal within the time available. Fire catch my factory, call agent 12 o'clock at night or 1:30 in midnight. That fellow will be sleeping. He may not even lift the call. At that time, let him lift. Up to then, I will see the picture. Nothing will be there. Ashes will be left out in the morning. So, agent should not be in a position to communicate with the principal. That is condition one called as emergency. There should have been actual or definite commercial necessity for agent to act promptly. Means, if you do not do this, for 5 lakh, if you see 5 crore rupee worth of goods will be going out. Agent should have acted bona fide. Means, good faith. Not for his benefit, for benefit of the principal he might have done. That's called as a bona fide. Bona means good, fide means intention. With a good intention he must have done for the benefit of principal. Agent should have adopted the most reasonable and practicable course of action. Means what? Normally fire catched. Immediately what anyone will do will bring a bucket and put on fire. You should call fire. At that time, they said that to erupt that file, you close that, it will take 5 lakh rupee. Then what ordinary person will do? They don't bargain at that stage. They will tell, please come on. The agent must have been in the possession of the goods belonging to principal. Factorial goods of the principal only there. That's it. 5 points. Very, very important. Okay. What is the next concept? The next concept we are going to discuss is sub-agent, substituted agent. Sub-agent, substituted agent. I will first tell you the logic. After that, you read. Okay. Sub-agent and substituted agent. Let us first talk about sub-agent. Principal appoints an agent. Principal appoints an agent. Agent will appoint a sub-agent. Generally, for the acts of sub-agent, principal will not become liable. Okay, for the acts of sub-agent, agent is only liable. Because sub-agent and agent between, like, agent is the principal to the sub-agent is the agent of the sub-agent. I did not understand. Principal agent, na, clarity is there, third party. Here, who are there? Principal, agent, sub-agent, third party. Sub-agent will act with a third party for the acts of sub-agent. For the acts of sub-agent, agent will become liable. For the acts of agent, principal becomes liable. But point is, sub-agency is not allowed generally. Principal should agree for sub-agency. If we agree, the whole scheme will change now. How it will change? Let's read. See, sub-agent is a agent of agent. Substituted agent is the another agent of the same principal. Another agent of the same principal. What is the difference? We'll discuss. Let us complete sub-agent first. The term sub-agent is defined as following. A sub-agent is a person employed by and acting under the control of original agent. So agent appoints a sub-agent. Principal don't appoint sub-agent. Principal appoints substituted agent. Thus, a sub-agent is an agent appointed by the agent. Sub-agent is an agent appointed by the agent. The relationship between sub-agent and original agent is that of agent and principal. That's what I told you. Sub-agent is the agent to the agent. The original agent will be the principal to the sub-agent. So therefore, what is the relationship existed between agent and sub-agent? Principal agency relation. What agency? Principal agency. How principal agency relation works? Same like that. Agent and sub-agent relation also will work. The general rule of law is that agent cannot delegate his powers to another without consent of principal, because there is a Latin maxim, delegatus non potest delegare. Delegatus non potest delegate means a person, delegate cannot delegate to some other person. If I tell you to do something, you should do. You should not give that power to some other person. So without my consent, if you appoint, that appointment of sub-agent will become void. So the contract of agency is a fiduciary nature. Fiduciary means ethical. It is based on confidence reposed by principal in the agent. Therefore, agent has no authority to delegate his other. Generally, sub-agency is not allowed. The agent is responsible to the principal for the acts of sub-agent. That's what I told. Sub-agent has done some wrong. For that, agent will become responsible to the principal. The sub-agent is responsible for the acts of the sub-agent is responsible for his acts to the agent and not to the principal, because principal did not appoint you. Agent appointed you. Privity of contract is between agent and sub-agent, not sub-agent and principal. Therefore, for the acts of sub-agent, agent will become liable, not the principal. The agent is responsible to principal as well as to the third parties for the acts of sub-agent. Sub-agent is not responsible to principal at all. He is answerable only to the agent. In simple, principal, agent, sub-agent, third party. Sub-agent has done something with third party. Agent will be responsible to the third person. One. For the acts of this sub-agent, agent will be responsible to third party, and agent is also responsible to the principal. So when appointing a sub-agent, you should be very, very careful. So, however, in the following cases, agent may appoint a sub-agent. When the agent may appoint a sub-agent? Number one, where it is expressly allowed. Means the principal has said very clearly, appoint him. Where principal know that agent intends to appoint sub-agent, but he does not object. Silence taken as an acceptance. Okay. Where custom of the trade permits the appointment of sub-agent. Means what? Generally, in the nature of the trade, sub-agent appointment is mandatory. Everyone know that. For example, sir, construction. I called one contractor. Koushik Mukhesh is constructing a 5-floor building, dream house. He called one engineer. He said, "Are you a civil engineer?" He said, "Yes, sir." I am saying, "Please construct house for me." Yes. I said that, "Sir, I will take 20 lakhs. I will give design, interiors, everything. I will do that. 20 lakhs is my fees." I said, "Okay, you construct 20 lakhs." I have given him. The next day, he recruited 100 labor. I said, "Hey, I asked you to construct. Why you are putting some other person?" And I should construct, I should construct, and I should put all my weights on my head and I should do that. Sub agent will do. I will appoint another person, he will do on my behalf. I did not give you permission. Array, construction business liability is implied that person to whom you gave contract will not do. He will deploy other persons as his agents to do. So therefore, sub agency can't be denied in case of construction. Everyone understood the difference? Everybody understood? Next. Where the act to be done is purely ministerial and does not involve any exercise of discretion or skill. Means what? It is not on discretion or skill. It is only labor work. Okay, in that case, you can appoint sub-agents. Where unforeseen emergency arises, which makes appointment of sub-agent necessary. Where sub-agent is properly appointed, the principal is bound and liable to third parties for his act. Okay, sub-agent is not responsible to principal, but principal will be liable to the third party. See, acts of sub-agent ki agent become responsible. Already what we read, act of agent ki principal will become responsible. So therefore, agent has done something, means principal is liable to third party. Now what happened? Previously agent and principal. Now sub-agent will do something with third party. For that, agent is responsible. For the act of agent, principal is responsible. So principal is liable indirectly to third party. Later, principal will punish the agent, not the sub-agent, for the wrong acts of sub-agent. Where sub-agent is not properly appointed, principal is not bound to the acts of sub-agent. Is we completed the concept of sub-agency. So simple language, normally delegators, non-protest delegate, means delegate can't delegate to some other person. Okay, you should do what you have to do. That's all. You have no right to delegate to some other person the same powers. Up to here, everyone understood. Second one, whenever the sub-agent is appointed, you should appoint only as per the requirement. Number one, principal should allow directly, expressly, or implied authority should give, or the trade should permit that. Okay, trade should permit. These are the mainly three things, or in emergency appointed. But when you appoint a agent, sub-agent in a proper way, sub-agent with act with the third party, agent is responsible. For the act of agent to the third party, principal is responsible. So indirectly, principal is responsible to the third party for the acts of sub-agent. If some wrong happens, na, agent principal will slap the agent will slap the sub-agent. The point. Appointment is invalid na. For the acts of sub-agent, agent is responsible. Principal has no responsibility for that. Now, second one, substituted agent. Sir, what is a substituted agent, sir? Sometimes agent cannot do certain things. He has no authority to do. Another person will be given an authority to do such things. Such kind of situations we call as substituted agent. Substituted agent is not an agent appointed by agent. He is an agent appointed by principal to do such acts which my agent cannot do. Which my agent cannot do. For example, sir, see, A wanted to sell his house property on an auction. On what auction? So A wanted to sell his house on an auction. Okay. He kept Mr. B as a agent. What B will do? B will go to so many people, tell about the house, take their auction document bidding, conduct a bidding process, everything B will take care. He is a agent to A. If B does something, A is liable for that act. Like that, both are having an arrangement. But auction to be conducted by an auctioneer. Auctioneer should be an advocate having experience in auction. That my agent cannot do. Therefore, I will appoint another person as an auctioneer on my behalf to conduct the auction process on behalf of principal directly. Since my agent cannot do that, now this person appointed as a agent to conduct the auction process, since the original agent cannot do, now you are called as a substituted agent. Substituted agent is appointed by the agent to act for the principal. Sir, you said principal will appoint. Agent will appoint with the permission of principal. Okay. In the business of agency with the knowledge and consent of principal. That's what I wanted to tell. But technically, principal will tell to agent, appoint a substituted agent. Then agent will appoint. But remember, sub-agent is responsible to agent, but substituted agent is responsible to principal. That's important. Substituted agents are not sub-agents. They are agents of principal. That's what I told now. Where the principal appoints an agent, and if that agent identifies another person to carry out the acts ordered by principal, then the second person is not to be treated as sub-agent, but only as a original principal. Read again. Where principal appoints an agent. Very good. And if that agent identifies another person to carry out the acts ordered by principal, means I'm sub-agent is a agent to the agent, but substituted agent is a agent appointed for the principal. Then he is not a sub-agent, he is a substituted agent to the original principal. While selecting substituted agent, agent is bound to exercise same quality of diligence. Okay, diligence means care. Okay, if he does so, and as a man of ordinary prudence, and if he does so, he is not responsible for acts or negligence of substituted agent. I said appoint a good auctioneer who brought a non-experienced auctioneer, recently qualified 20 to 23 years advocate you brought. He did not conduct properly because of the loss occurred. Then agent will become responsible for putting a wrong substituted agent. Example also I have given. Auction example I have given here. Differences, I am leaving it for you to read. Just read and leave the differences. With this, we completed part 2 of agency chapter. Okay. Everybody answer. Part 1, part 2, part 3. We have completed 2 parts in the agency area. Everybody understood the concept clearly? Okay. Giving some time. Read this particular part. Differences just to understand. Sorry. Just to understand. Treated. So these are all the differences between these things. So sub-agent works under the control and directions of agent, but he is under the control of the principal. Agent delegates to sub-agent a part of his own duties. Agent does not delegate any part of his duties to substituted agent. So he will do different things that he cannot do. There is no privity of contract between principal and sub-agent, but here there is a privity. Sub-agent is responsible for agent alone. Substituted agent is responsible for principal. Okay, next. Agent is responsible to principal for the acts of sub-agent. Agent is responsible to principal for acts of sub-agent. Agent is not responsible to the principal for the acts of sub-agent, substituted agent. Generally, if it is irresponsible person because of him, then chance, the extreme case. Sub-agent has no right of action against the principal for remuneration due. But substitute agent can sue principal because he is acting for that principal only. Sub-agents may be improperly appointed, means without the permission. But substituted agent can be appointed only with the permission of principal. Then where is the question of improper appointment? Person appointed may not do it properly, but appointment can't be improper. Agent remains liable. Agent's duty ends once he has been named as substituted agent. So these are all the various differences between sub-agent and substituted agent. Okay. With this, we completed the part 2 of this particular unit called as contract of agency. Now we are left out only with one small part. These all are general concepts. Rights and duties of agent 2 pages. Okay. Liability towards third party. Rights of third party. Termination of agency. Termination of agency is irrevocable. 4 concepts will be there. 5 pages discussion. But very, very easy area. The most difficult part of this entire chapter is completed with this. From now, all same similar masala will be added everywhere. Nothing new, nothing great we are going to see in the rest of the part of unit of this particular contract of agency. So I'm stopping with here with part 2. Part 3 we will continue in the next class. So in detail we are going to discuss also about part 3 and we'll have full clarity on the contract of agency. Then our workout we will do. Means what? All the questions and answers we will put and we will do that. Okay. Thank you.